And hi everyone for joining us today. Just our quick disclaimer, this presentation is for educational purposes only. It's not legal advice and does not create an attorney-client relationship unless you're already a client, of course. We'll have some information at the end on contacting us if you have specific questions. Also, so you can get on with your day, we'll move through this information somewhat quickly. So for today, we are talking about an important topic, one that's been in the news, one that is a concern to most employers in the US, and that's the joint employer rule. And we're focusing specifically today on staffing agencies. So we'll talk about the National Labor Relations Act generally, the joint employer rule, and then how you can get some help. So just as kind of a quick overview, what is the NLRA? Again, National Labor Relations Act. It's an old law. It was passed in 1935 as part of the New Deal under President Franklin Roosevelt. Guarantees the right of private sector employees to organize into trade unions, engage in collective bargaining, and take collective action such as strikes. It also bans what are called company unions, but we're not going to get so much into that today. One of the questions that we've heard, in kind of cutting to the chase on the topic, is, but I'm not a union shop. One thing that employers need to understand about the NLRA is that it still applies to almost every employer in the US, and particularly to private employers. The reason why the law applies is that there is a presumption of inherent inequality between employers and employees, basically meaning that this rule presumes that employers have the upper hand over employees, and so the rule is meant to level the playing field to an extent to assist employees in trying to be able to more successfully engage with their employer. Specifically under the National Labor Relations Act, it's Section 7 that protects employees' concerted protected activity. And that is kind of the important piece that this new rule of joint employment deals with, which we'll discuss in a little bit. I think it's also important to kind of provide a brief history of the joint employer rule, just so you can kind of get your head around where things are at now, where things kind of were before, and where the changes are being made. So prior to 2015, so meaning basically from the start of this law in 1935, a joint employer relationship between two different companies was determined if an employer exercised, and this is important, direct and immediate control over the essential terms and conditions of employment. That would mean that to be tagged as a joint employer, you'd have to have some sort of, again, direct and immediate control over another company's employees. Things began to change with the what's known as the Browning-Ferris decision. That was in 2015. That was during 2 administrations ago under the President Obama. That rule upended significantly the previous 70 years of employment law, and under Browning-Ferris, joint employers were then noted to include organizations that had reserved or indirect control over employees. So you didn't even have to exercise control to be considered a joint employer under that rule. It just had to be reserved and indirect. There was a 2018 lawsuit that challenged that law because it was such an upending of precedent, and there was a 2020 ruling called Browning-Ferris 2, which again went back to the standard of substantial direct and immediate control over the essential terms and conditions of employment to be considered a joint employer. And this made much more sense to employers who work with other companies versus that newer standard that was reserved and indirect control. That did not make sense to most employers. Again, the 2020 rule went back to the substantial direct and immediate control rule. Well, then some things got upended in 2020. There was a lawsuit challenging the 2020 joint employment rule. And then for 2024, we have the pendulum swinging back with a different federal administration that is more employee friendly, more organized labor friendly, and less employer or business friendly. They kicked out this new joint employer rule. So under the new joint employer rule, 2 or more entities can be considered joint employers if, number 1, they have an employment relationship with common employees, and number 2, they share or co-determine at least one of the essential employment terms and conditions. So under the new rule, a business is a joint employer if it has the right to exercise control over any of 7 enumerated terms and conditions of employment, which we'll talk about. And this is the rub though, even if that employer never exercises that control, and even if the only way it could exercise such control would be through an intermediary. So this gets away from the old, for many decades, standard of direct control and into, again, that indirect and reserve control rule, which is much less favorable for businesses and employers. So what are those 7 employment terms and conditions of control that the NLRB rule for joint employment touches upon? And again, this is to determine if 2 entities are a joint employer of employees. So those essential terms of employment include wages, benefits, and other compensation, hours of working and scheduling, and of course, with almost any business, that could come into a play if employees are going back and forth. Assignment of duties to be performed. Again, that could touch almost any company where employees are going back and forth, including for staffing. Supervision of the performance duties. Work rules and directions governing the manner, means, and methods of the performance of duties and the grounds for discipline. So think of with staffing, you send your employees to an employer who's got, ground rules for people to observe. The tenure of the employment, including the right to bring somebody on board or get rid of them. And finally, working conditions concerning employee safety and health. That obviously is a big one because most private employers have some sort of rules for people that come onto their property regarding safety and health. So why should you care about this new joint employer rule that again moved away from decades of precedent requiring direct control to the indirect and even reserved control standard under the new rule? Well, the reason you should care is that obviously it threatens existing relationships, particularly in staffing. There are concerns for ongoing agreements with clients. And the rule also imposes obligations that weren't considered at the inception of the relationship. Again, if you're a staffing company, or this also affects franchise or franchisee relationships or any sort of outsourced agreement. Maybe you've got a fire suppression services vendor that comes onto your property once a year to inspect your sprinkler and your alarm system. The way that this rule, the new rule, has been written, it is a broad expansion of the potential of a joint employer status in a way, again, that wasn't even considered by parties when they enter into agreement to do business with each other. This applies to private sector employees, across the board, and it's really kind of an overwhelming situation that a lot of employers are looking at. So one piece of good news is that with this joint employer rule, it affects only the National Labor Relations Act. And again, as we talked about, that goes back to concerted protected activities by employees, basically meaning unionization. So this new rule only covers that. It does not affect determinations of joint employment under their federal wage and hour laws, and it does not affect any state laws regarding joint employment. But again, the first piece of bad news that we had was this is such a broad expansion of the rules that it affects existing relationships in ways not anticipated. But it also means that employers who are caught up under this new rule, if it stands, and we'll get to that in a minute, is that if you're determined to be a joint employer under this NLRA new joint employer rule, you have a duty, not an option, a duty to negotiate with unionization talks, and you could be held to an unfair labor practice if you do not do so. That is really kind of a, in my opinion, kind of a stretch for what the rule was intended to do, to drag in all these other individuals that didn't anticipate being caught in that sort of situation. Now, as an employer, if you're thinking that this is too much of an expansion of a law and potentially could have too much of a negative impact on my business, there are some things that are happening to try to mitigate or stop the new rule from going into effect completely. The rule was originally supposed to go into effect in late December of 2023. The rule effective date was extended to February 26th of 2024, which is actually next Monday. In the meantime, there has been a coalition of pro-business agencies that have filed a lawsuit looking to stop this rule, basically. They filed in the Fifth Circuit, which is includes Texas. That's a federal court circuit. And you may remember back to late 2016 when there was supposed to be a change to the exempt employee rules, including an upping of the salary threshold. The Fifth Circuit is the circuit that stopped that new rule from going into effect. So I think the pro-business organizations that brought this case selected their venue for the case very carefully, trying to land in a more pro-business jurisdiction, basically, of the Fifth Circuit. So the lawsuit, a hearing was held on the lawsuit last week. It's currently under advisement with the court. So there are a few things that could happen between now and next Monday, the 26th of February, 2024, when the rule is supposed to go into effect. One is that between now and Monday, the National Labor Relations Board, who again put this new joint employer rule out, they could decide they didn't like how the hearing went, so they are going to voluntarily extend the date for when the rule will begin past February 26th. That has not happened yet, but that is a possibility of something that could happen between now and next Monday with the rule. Again, the agency could say, while this court case is pending, we're going to extend the date of the effectiveness of the new joint employer rule out to a future time. That could happen. Another thing that could happen in the meantime is that the court could come back with a ruling between now and the 26th of February. Again, this is federal courts. They can put injunctions on rules that could potentially have a national implication. That's what happened with the overtime case in 2016. Just days before that new rule was supposed to go into effect, the Fifth Circuit stepped in and said, no, this is not happening, and the rule was suspended indefinitely. Now, again, we don't know what's going to happen between now and Monday, but there's a possibility the court could put an injunction on enforcement of the rule. The court could make some other type of determination affecting the rule. It just hasn't happened quite yet, but that is a possibility for those that are more on the business side of things, for a way that the rule could be suspended or stopped. There's some other pieces out there. The SEIU, which is a large labor group, they brought a case, but they basically said the rule didn't go far enough. So that's hanging out there. The Strange Bedfellows of Elon Musk and Trader Joe's also brought a case, but the basis for their case was that the National Labor Relations Board in general isn't constitutional. That is a real foundational type of in the weeds constitutional argument. Nothing is likely to happen with that. Legislative actions at this late date, it's very unlikely something would occur. So what should companies do? Again, since we're not sure what's going to happen between now and next Monday, if anything, here are some thoughts to have as a company. The other piece to consider is that, before we get into this, is that the National Labor Relations Board itself is not likely to go out if this rule goes into effect as is and try to track down companies to sue. Instead, what is more likely to happen is that there will be very specific companies where a joint employer rule unfair labor practice charge will be brought against. And so think of big companies as the starting point. That is much more likely than a small company being targeted for enforcement under this rule. The problem, of course, is that with this type of rule being so broad, the enforcement can be very arbitrary, it can be very capricious, and it can be very inequitable. But again, if it were to go into effect next Monday as is, it's more likely that the cases would come in on big companies to start with. So what can you do in the meantime? Review your staffing agency agreements and independent contractor agreements. You want to look at in this PowerPoint the 7 factors that we discussed on a previous slide, and look in your contracts to see, are there any explicit, implicit, or implied rights of control? That's an area where you can start to limit your risk in your dealings with another entity. You may also then, if you find something where you feel you have some concerns, you may want to look at amending your contracts with those other parties, and then again, draft future contracts with an eye on the 7 factors on the previous slide to kind of avoid those issues. If you find yourself in that position, you can reach out to the other party and have a negotiation, a discussion with them saying, hey, for our mutual benefit, if we don't want to be joint employers with each other, let's, as a team, work through this and work out a resolution with a contract amendment or a new contract to get some of those issues worked out. And with any future agreements, you'd want to keep those 7 factors in mind. Again, that's saying if the law isn't completely blocked by the federal court in Texas, if it's not postponed further, or if it's not changed in some way. These are just kind of a general best practices that can be looked at now, and kind of think about where you're getting into the 7 risk factors discussed on the previous slide in your relationships with other employers. The other thing to do is, when you have questions, ask. If you are one of our clients, send us a ticket and just ask about some of the considerations that we've discussed today. We also, if you're not a client, you can look at signing up with us, and we've got some additional information on the next slide for that. Remember, everybody, like we always say, compliance is not optional, but myHRcounsel is here to assist with your compliance issues. Thanks, everybody, for listening today, and we'll see you again next week with another myHR Minute.